If you decide to file a lawsuit or get yourself involved in some type of legal case, there are going to be times where you may have to need loved ones, meaning family or friends or even coworkers, to provide information that may be necessary to assist you with your case. So for the next 3 videos, I want to talk to you about what needs to happen in order to prepare your loved ones for their involvement in your case. And today, we're going to talk about explaining to them their role in your case. Depending on the type of case that you have, there's going to be things that you're going to need to be able to provide to the entity that you're going before in order to demonstrate that you should prevail in your case. Some instances it's going to require you to reach out to people who are in your personal circle in order to assist you. So when you're starting to find yourself in a position where you're getting yourself ready, if you're in ability to do so, if legally you're permitted to do so, start preparing your loved ones by explaining to them what their roles may be in your case. There are 3 particular areas where they're probably going to be involved. It can either be as a witness, it can either be to provide evidence, or it could be just at the various stages. So let's take each one at a time. As a witness, they may be asked to come forward in at least 3 capacities at least. They can be asked to come as a character witness, which means they're there to testify as to your character. They could be there as an evidentiary witness, meaning there's a part of your case that you're trying to prove up, and their participation in it, whether it be as a witness or someone who actually had the evidence itself, may be necessary for them to testify to that. Or what's called a rebuttal witness. That means where the other side has provided some witnesses, and in order to counter that statement that person made, you want to use your own witnesses to use that as well. The providing of evidence. And like I said before, it could be in a variety of capacity. It could be through statements like affidavits or written statements under oath. It could be through testimony. It could also be through the fact that they actually have hands-on the evidence, meaning they are the custodian of whatever evidence that's necessary to utilize for your case. Also, it's important that you make sure you let them know that there may be different points of your case along the way that their roles may be needed. Your case is not going to be quick. So from the time you file to the time you get a final judgment in your case, there's a lot of different steps along the way, and they may be a necessary part of it. It could be at the very early stages during the investigation process. It could be during the discovery process, which means you may need them to be a deponent, meaning they may need to get deposed in terms of a deposition. There may be certain hearings along the way that their testimony may be necessary. Or if it goes to trial or a final hearing, they may have to come there and testify on your behalf. So when you're talking to your loved ones, just let them know, just so they don't think in their mind that they only have to help you one time, that there's going to be different points at a time that they may have to come back and provide ongoing information, even if it's the same thing, because at different parts of the process, their assistance may be necessary. If you are legally permitted to do so, take whatever chance you can to prepare your loved ones for the reality that they're going to be a part of your process. So this way you explain to them what their role is going to be. So this way they're not shocked when you come and you ask them to participate in these capacities.